A California legislative explainer on effective versus operative dates. There's often confusion regarding effective or operative dates in California statutes. Specifically, individuals may inquire when a statute actually takes effect. When it takes effect can be different from when the statute is operative. Now, January 1 following the year that a bill was enacted is the most common effective date, and it's basically the default effective date. It's also the default operative date. A common definition of effective date is when the bill is, or the new law actually is on the books, so to speak. Now, there are certain types of bills that are deemed to be in effect upon enactment. That is, when the governor signs them and the Secretary of State assigns a chapter number. However, unless the bill calls an election, contingent urgency clause, is a budget related bill, or a tax levy, one can presume that the effective date of a new law is January 1 of the following year. On the other hand, a common definition of operative date is when the new law becomes operative, which commonly but mistakenly is described as when the new law is in effect. Any bill can specify what we call a delayed operative date, that is, have a date after the January 1 following enactment as its operative date. An operative date is distinguished from an effective date, and it was said in an Attorney General opinion way back in 1956 that a statute may be worded so as to provide for an operative date other than its effective date. An operative date, therefore, may be the same as the effective date, or it may be a different later date than the bill's effective date.